Okay, so I need you to stay with me here because what I'm about to tell you is genuinely unprecedented in American constitutional history. And I mean that literally. I don't use that word lightly. In 1974, when the House Judiciary Committee was building its case against Richard Nixon, the question arose about what role the courts should play in impeachment. Could a judge tell Congress what to do? Could a judge force Congress to act? The answer historically has always been no. The courts stay in their lane. Congress stays in its lane. The separation of powers means separation. Full stop. That was the understanding. That was the norm. That was the wall until Dre Chen PMP Kempa Eastern Time today. Here's what happened. Federal District Judge Tanya Chutan, who has been presiding over Donald Trump's federal election interference case, did something that no sitting federal judge has ever done in the 236-year history of the American Republic. She issued a formal criminal referral to the House of Representatives. Not a suggestion, not a recommendation, a formal criminal referral triggering impeachment proceedings against a former president who is currently facing active prosecution in her courtroom. And I want to be very clear about this because precision matters right now. This is not rumor. This is not anonymous sourcing. This is not speculation from people who claim to know things. This is a 47-page document filed in federal court at 3:17 p.m. Eastern Time. It has a case number. It has a timestamp. Anyone can read it. And the language in that document is extraordinary. Quote, "The defendants' repeated violations constitute a clear and present danger to the administration of justice and demand immediate congressional intervention." Clear and present danger. Immediate congressional intervention from a federal judge in a court filing. Now, here's the thing. To understand why Judge Chuck Kahn did this today, you have to understand what's been happening in her courtroom over the past 3 months. 14 times, 14 separate occasions, Donald Trump violated the gag order in his federal case. Each time, Judge Chuckin held hearings. Each time she warned him, each time she warned him. Each time she documented the violation. But the violations didn't stop, they escalated. And then the evidence started emerging that this wasn't just about social media posts. This was about direct contact with witnesses, phone records showing coordination with co-defendants who were under court-ordered no-contact provisions, direct messages to people scheduled to testify, internal emails from Trump's own legal team acknowledging that violations were occurring, and then, and this is important, recorded conversations, recordings where Trump discussed with advisors how to defy court orders. Not just defiance, intentional defiance, planned defiance. That's when the pattern became undeniable. This wasn't a former president who was struggling to control himself on social media. This was systematic obstruction. This was witness tampering. This was contempt for the entire judicial system designed to hold him accountable. What Judge Chuck Kahn sent to Congress today wasn't a summary. It wasn't a letter expressing concern. It was a comprehensive evidentiary package. 14 documented gag order violations with timestamps and screenshot. Transcripts of 7 contempt hearings where Trump was explicitly warned about consequences. Evidence of direct messages to witnesses in his criminal cases. Clone records showing coordination with co-defendants. Social media posts threatening prosecutors, threatening judges, threatening potential jury pool members, internal emails from Trump's legal team, expert declarations from former federal judges about the unprecedented nature of this conduct, and the recorded conversations, the ones proving intent. Judge Chuckin transmitted all of it, everything, a complete roadmap for impeachment built on evidence she collected in her own courtroom. This has never happened before. Not during Watergate, not during the Clinton impeachment, not during either of Trump's previous impeachments. A federal judge has never said to Congress, "Here is documented criminal conduct. Here is the evidence. You must act now." And here's where this gets even more significant. The House was ready. Articles of impeachment have been sitting dormant since November 2025. 8 specific charges: obstruction of justice, witness tampering, contempt of court, violation of court orders, abuse of power, conduct unbecoming threat to constitutional order, and incitement. As of yesterday morning, those articles had 87 co-sponsors, all Democrats, not enough to move forward. But when Judge Chuck's referral hit Congress at 3:17 p.m., something shifted. As of this morning, those articles have 231 co-sponsors. 231, a majority of the House of Representatives, enough to impeach right now. And the names that have been added are not the names you would expect. Representative Mike Lawler of New York, a Republican from a Biden-won district who defended Trump through 2 previous impeachments. He held a press conference this morning and said, and I'm quoting directly, "I took an oath to the Constitution, not to any individual. When a federal judge says a former president is obstructing justice, I have to listen." Representative Don Bacon of Nebraska, another moderate Republican who has been a reliable Trump vote for years. He signed on this morning. The dam is breaking. Democratic leadership has now invoked Rule 9, Section 2. That's a fast-track mechanism in House rules that forces a floor vote within 72 hours of invocation. They filed the motion at 9:45 a.m. this morning, which means by Monday, January 13th, at the latest, the full House of Representatives will vote on whether to impeach Donald Trump for the 3rd time, 72 hours. That's the window. That's all the time left. And with 231 co-sponsors already on record, the outcome is not in doubt. The only remaining question is margin. Will it be narrow? 218 to 217, or will it become a landslide if more Republicans break ranks over the weekend? That number is growing by the hour. Moderate Republicans in swing districts are watching footage from the Capitol. They're reading the judge's referral. They're calculating what attack ads will look like in the 2026 midterms if they're on record defending documented obstruction of justice. And they're jumping ship. Now, here's where I need you to really pay attention, because this is where the situation becomes genuinely dangerous. Donald Trump has been posting continuously on Truth Social since approximately 4:00 p.m. yesterday. All caps rants about rigged courts, attacks on what he calls Obama judges, claims of political persecution, standard rhetoric, expected rhetoric. And then came the post that has alarmed law enforcement, national security officials, and constitutional scholars alike. Quote, "If Congress moves forward with this witch hunt, patriots must converge on Washington. The Second Amendment exists for moments like this." I'm going to read that again. Patriots must converge on Washington. The Second Amendment exists for moments like this. That is a former president of the United States calling for armed resistance to Congress. That is not campaign rhetoric. That is not political bluster. That is incitement. That is potential seditious conspiracy. And every post he makes becomes additional evidence in the case against him. He cannot stop himself. He is making things worse with every keystroke. And he doesn't seem to understand or doesn't care that everything he posts is being documented, time-stamped, and will absolutely be used against him. The consequences of that rhetoric are visible right now in Washington, D.C. The National Guard has been mobilized. Units are deployed across the Capitol complex as we speak. Steel barricades are going up around federal buildings. Pro-Trump demonstrators are gathering near the National Mall. Counter-protesters demanding accountability are forming near the Supreme Court. Law enforcement is everywhere. FBI field offices across the country are monitoring far-right militia channels for chatter about mobilization. This is what January 6th taught us. You cannot dismiss Trump's rhetoric as empty. "Be there will be wild" was dismissed as empty. It wasn't empty. The Second Amendment exists for moments like this is not empty. Authorities are treating it with deadly seriousness. That's why the National Guard is deployed tonight. That's why official Washington is not sleeping. Once the House impeaches, and with 231 co-sponsors, impeachment is now a certainty. The process moves to the Senate. A trial becomes mandatory. Chief Justice John Roberts will preside. House impeachment managers will present evidence drawn directly from Judge Chuck Gunn's 47-page referral. Trump's legal team, whoever is still willing to represent him after his last 3 attorneys withdrew in November, will attempt a defense, and then 100 senators will vote. Conviction requires 67 votes. Every Democrat plus 18 Republicans. That sounds like a high bar, and historically it has been. Trump survived 2 previous impeachment trials because Senate Republicans held the line. But look at what's happening right now. Senate Republicans who have been solidly in Trump's camp for years are hedging. They're not defending him the way they used to. They're talking about concerns and troubling conduct and need to review the evidence. Senators from swing states, Pennsylvania, Wisconsin, Arizona, Georgia are watching the footage from the Capitol. They're reading the judge's referral. They're imagining attack ads. They're calculating survival. And Senate Minority Leader Mitch McConnell is reportedly furious. Furious about Trump's Truth Social post threatening armed resistance. That post directly endangered McConnell's members. It painted a target on every Republican senator who might vote to convict. McConnell has survived one assassination attempt. He's not interested in another. And he's not interested in Trump getting his colleagues killed either. Here's something else that's critically important. Judge Chuck Kahn's referral didn't stop with Congress. Evidence of witness tampering, obstruction of justice, and criminal contempt has also been transmitted to the Department of Justice. If investigators can establish that Trump directly coordinated with witnesses to change their testimony, that's subordination of perjury. That's a serious federal crime with significant prison exposure. Witness tampering carries prison time. Obstruction of justice carries prison time. Criminal contempt carries prison time. Multiple federal grand juries are already active in Washington, in Miami, in Atlanta. It is entirely possible, I would say probable at this point, that additional criminal indictments arrive while Senate impeachment proceedings are still underway. We are now in territory that the framers of the Constitution anticipated, but hoped would never be necessary. Multiple accountability mechanisms operating simultaneously. Congressional impeachment, Senate trial, federal criminal prosecution, all of it converging on one individual at the same time. And then there's this. I want to be careful here because this is based on reporting from multiple outlets, not on official statement. But reports indicate that there have been quiet discussions, very quiet discussions between cabinet officials and Vice President J.D. Vance about the 25th Amendment. The 25th Amendment allows for the removal of a president if he is deemed unable to discharge the duties of office. It doesn't require impeachment. It doesn't require a trial. It requires the vice president and a majority of the cabinet to declare the president incapacitated. It can happen quickly, overnight. Trump could contest it. He could send a letter to Congress saying he's perfectly capable of performing his duties, but then the cabinet would have 4 days to respond. And with impeachment already moving forward, the outcome of that contest would not be in doubt. The fact that this option is even being discussed, the fact that cabinet members are reportedly having these conversations tells you how severe officials inside the government believe this situation has become. The Republican Party is tearing itself apart in real time. On one side, you have the loyalists, Marjorie Taylor Greene, Matt Gaetz, Jim Jordan. They're doubling down. They're calling for protests. They're defending Trump unconditionally. They're threatening primary challenges against any Republican who votes for impeachment. On the other side, you have the pragmatists, the Mike Lawers, the Don Bacons, the Republicans from swing districts who survived 2024 by running ahead of Trump. They're fleeing. They're citing their oaths to the Constitution. They're talking about the rule of law. And in the middle, you have everyone else watching, waiting, calculating. Internal threats are being made. Lawmakers who have defected are receiving harassment from Trump's base. Phone calls, emails, social media attacks, in some cases, threats that have been referred to the Capitol Police. The party is fracturing under the weight of Trump's collapse. And with the 2026 midterms just 10 months away, many Republicans see electoral disaster ahead if they remain tied to this chaos. They're not wrong. One more dimension that deserves attention. America's allies are alarmed. A former American president threatening armed resistance while facing impeachment is not a normal headline. It's not a headline that inspires confidence in American stability. Our adversaries, Russia, China, Iran, North Korea, are watching closely. They're calculating risk. They're probing for weakness. Domestic instability always has global consequences. And right now, to the rest of the world, America looks unstable. America looks like a country that cannot manage its own. Internal conflict. America looks like a country where the rule of law is under attack from the people who are supposed to uphold it. That perception has consequences for our alliances, for our credibility, for our ability to project power and influence on the global stage. I want to step back for a moment because I think it's important to understand what Judge Chukan actually did today and why it matters so much. For decades, for the entire post-Watergate era, there has been an understanding in American government. The courts handle prosecutions, Congress handles impeachment. Those tracks run parallel, but they don't intersect. That understanding is now shattered. A federal judge has said, "This conduct is so severe, this obstruction so systematic, this threat to justice so immediate that I am formally intervening. I am telling Congress that action is required. I am transmitting evidence directly to the legislative branch that changes the balance of power between the judiciary and Congress in ways that constitutional scholars are only beginning to process. And it eliminates a strategy that Trump has relied on his entire life. The strategy of delay, run out the clock, appeal every ruling, file every motion, wait for the election, wait for the statute of limitations, wait for everyone to get tired, and move on. That strategy is no longer available. The judicial clock is now running. And when a judge says Congress must act, Congress cannot pretend the deadline doesn't exist. Here's something else that Trump's allies understand, even if they won't say it publicly. This isn't the end of exposure. This is the beginning. Senate impeachment trials bring subpoenas. They bring sworn testimony. They bring document production. Every layer that gets peeled back creates new legal risk. And not just for Trump. For the staffers who carried messages to witnesses. For the donors who funded legal defenses designed to delay justice. For the political operatives who coordinated social media attacks on judges and prosecutors. For the lawyers who filed frivolous motions knowing they violated ethics rules. For the advisors who counseled contempt. All of those people thought loyalty would protect them. They're suddenly realizing that loyalty only ties them closer to the blast radius. When that realization sinks in, cooperation becomes the rational move. Silence becomes dangerous. And once that shift begins, once the first person decides to cooperate, it accelerates because everyone else calculates that they don't want to be the last person holding the bag. Trump senses this. You can see it in his posts. He's not posting to persuade voters anymore. He's posting to threaten institutions. Calling for armed patriots to converge on Washington isn't political messaging. It's intimidation. It's designed to make House members hesitate, to make senators second-guess themselves, to make prosecutors fear consequences for doing their jobs. But here's what Trump doesn't understand or refuses to understand. Threats don't freeze institutions when they're documented in public. They harden them. Every post is archived. Every post is timestamped. Every post is potentially admissible in court. Every escalation strengthens the argument that Trump is not merely defiant but dangerous. He's making the case against himself in real time with his own words, and he cannot stop. So here's where we are. 72 hours from a House impeachment vote. A federal judge has formally declared that Trump's conduct constitutes obstruction of justice and witness intimidation. A majority of the House, 231 members, has already signed on to articles of impeachment. The National Guard is deployed across Washington, D.C. Federal criminal investigations are accelerating. The 25th Amendment is being discussed inside the cabinet. The Republican Party is splintering in real time. And Donald Trump is posting threats of armed resistance that only worsen his legal exposure with every keystroke. This is not noise. This is not cable news hype. This is not speculation. This is convergence. Everything that has been building for months, the contempt citations, the gag order violations, the criminal convictions, the appeals court losses, the defections, the warnings, is colliding into one narrow window of time. 72 hours. What happens in those 72 hours will shape the future of presidential accountability. It will shape the independence of the federal judiciary. It will shape whether the principle that no person is above the law actually means anything. I've been doing this for a long time. I don't say things are unprecedented unless they actually are. This is unprecedented. A federal judge formally triggering impeachment proceedings that has never happened. A former president facing third impeachment while simultaneously appealing felony convictions. That has never happened. A former president calling for armed resistance while the National Guard deploys around Congress. That is not supposed to happen. We are in constitutional crisis territory. Not approaching it, not heading toward it in it. And what happens next will be determined by whether the institutions designed to handle this kind of crisis, Congress, the courts, law enforcement, actually do their jobs. So far, Judge Chutkan did hers. The House appears ready to do it. The question is whether the Senate will do its and whether the American people will demand that it does. I'll be covering this throughout the weekend. The vote is Monday. Between now and then, anything could happen. Stay with us.